Oh, yeah. You argued the first. Our case. Sometimes.
They were two.
Oh, really? Huh. Right. I don't know. I think he didn't do the Zyler case. That one, talk about a case where the judge and the prosecutor would have been all totally embarrassed. You know what happened there. They, case had been knocking around years and years, maybe even more. These COVID, everything. Finally going to go to trial. February, okay, they adopted the got in under the wire. They knew it was coming, but they couldn't know. So they pick a jury, 3 days. Fourth day, they realized, oh my God, what happened? They were warned, telling them life means that. What they all forgot was parole was not that was mandatory. So they wound up not a mistrial, they caught striking the jury. It will start over in 2 months. So in 2 months when they started over, you had the 8 force. Everybody missed it. Two defense lawyers, 3 prosecutors, and the judge. And they did voir dire for 3 days, picking up on that. He'd not only be eligible for it, he couldn't waive it. And they 2 weeks earlier, the pre-trial hearing, they all knew it was a case. That's a case you should be. Oh, and by the way, the verdict was 10-2. I mean, that was bizarre. That was one of the, I mean, 40 some odd years. That was one of the strangest things. Yeah. Mm-hmm. That's not that uncommon. Right, well, I mean, well, I mean, right. I mean, if we had to raise every issue on at once, it would be impossible to do. My ace in the hole on that is Lawrence. Oh, man, you still get nervous before these? Too.
Oh, yeah. Maybe you're tapping my foot.
Well, that's true here as well. The only thing is, I much prefer questions. I hate it when they make me make a speech because I stumble. What the hell's the word? Yeah.
Something.
Right. Some people are very smooth at that.
Part of one of my other public speaking.
Where do you teach?
Sometimes I show the,
You showing videos?
yeah.
You showed them that one?
Yeah.
I
I mean, it's a good way to show that, this is also constitutional policy.
I'm going to say that right here.
Yeah.
Could be a live mic. How about that?
I had my answer.
Without going into the person who did that, done a lot, appeals for a long time. He did a couple of capital cases in Tallahassee that were bad. Ran into personal issues.
Yeah, well,
I was actually glad it was the way it was, because if it had been borderline, tougher to get him. Well, you'd think, I was actually I was an AG, appellate AG, Miami from 1980, a long, long, long time ago, but I have done your side. I can tell you tell me if this least favorite thing is to respond to pro se. It's the briefs.
they come up with the most, insane or clever.
Well, the problem, number one, I couldn't even read it. And then number two, the problem was, what I felt like I had to do is I had to take this incoherent stuff and try to figure out what is the best possible argument they might be making, and then try to respond to that.
Yeah. Remember the, what they called it, the sovereign citizen argument?
Oh, well, yeah.
Yeah.
We,
Can't charge me, I'm not a citizen here.
that's all tied up with all kinds of crazy bigotry, too.
Yeah. Yeah. I see those.
Oh, it hasn't gone away.
Oh, I think it started out as a.
Yeah, I think that, and I think you can, like with all history, you can trace it back either for posse comitatus or
Oh, yeah,
something. I
yeah.
think they trace
See
it
them
back.
cite that too.
Yeah. You ever hear of the Moorish Temple movement, which is kind of like the African-American equivalent of sovereign citizen? Moorish, M-O-O-R-I-S, like Othello, Moorish.
All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning. Our first case today is Figueroa Sanabria versus State of Florida, number 2024-0768.
May it please the court, I'm Steve Bulletin from the Public Defender's Office in Bartow. I represent the appellant, Rinaldo Figueroa Sanabria. I intend to focus my 20 minutes today on the case-specific issue regarding competency and waivers. But at the outset, I want to address a point on the constitutional issues regarding Florida's 8-4 statute that was left hanging at the very end of rebuttal in the Joseph Zylor argument back in February. Chief Justice Munoz commented at the end of that of rebuttal, "We could talk about this for hours. It's fascinating, morally compelling. It sounds like it's a great issue for the legislature." And as it was at the end of rebuttal, I didn't really have a chance to address that, and I was on a roll to make my lame Chicago White Sox comment. But the bottom line here is it's not an issue for the legislature. It's an issue for this court. It's an issue ultimately possibly for the United States Supreme Court. But it's the legislature that basically took what was probably a constitutional system as existed when we had proportionality and unanimity and somewhat fewer and less broad aggravators, and basically turned it into, by far, the worst in the sense of the least safeguards against unreliability and arbitrariness under the Furman Doctrine, the worst death penalty statute in the country by a wide margin, beating out Alabama and others. Florida is the only case that has neither proportionality or unanimity. Most have both, some have one. When you combine that with the breadth of the aggravators that make you death eligible now, if you say the three big safeguards, one for the penalty phase, one for the eligibility determination, one for the selection decision, and one for appeal. All three are gone. The legislature is who is responsible for doing away with unanimity and putting in 8-4. This court respectfully played a role, too, in the Lawrence decision by, my argument would be, misapplying Pulley versus Harris to say that proportionality is never required and it's not even permissible in Florida. Pulley did not say proportionality is never required. Pulley said proportionality may be required if there are insufficient other safeguards of reliability present, and Florida is there. So just to sum it up pretty quickly, Meatloaf said 2 out of 3 ain't bad. 0 out of 3 is bad. And so again, I would rely on my briefs. Other than what I just said, I would rely on my briefs as to why Florida's current 8-4 system is arbitrary and capricious under Furman.
Don't you think, though, that, I mean, I understand that if the goal is to just make it as hard as possible to for the death penalty to be imposed against a particular defendant, I understand why proportionality and unanimity are consistent with that. But it seems like the unanimity and proportionality could be said to introduce arbitrariness or unpredictability into the system as much as, you know, the alternatives. In the sense that proportionality is impossible to do objectively. Especially when you consider that you're having to compare not just the aggravation but the mitigation across cases, and how you could do that in any kind of objective way, I think is very difficult. And then with unanimity, you know, you see the random, you know, 11-to-1s in cases that are kind of inexplicable, and I don't see how that is sort of more prone or less prone to arbitrariness than 8-4.
Well, okay, addressing the unanimity first. I mean, to say it's with a trial on a non-capital case, a non-murder case in any courtroom in Florida, you will get cases where one juror for, I mean, I'm rambling here a little bit, but the legislature kind of got fixated on the thought of parkland, and they thought, and I don't think necessarily correctly so, but they thought that somehow, even though you had all these protections, that the state can voir dire too, they have preemptories too, but they thought that somehow some nullifiers got on that jury, and we really, really wanted to execute Nicholas Cruz, and we didn't get to do it, so there were 3 votes for life in Nicholas Cruz, so we're going to make it 4. The thing is, I mean, there are protections against rogue jurors. I don't think rogue jurors is a real problem. I think it's a pretextual problem. There is case law in every, under Ramos, for example, it does not make any sense to me, at least, to say that the Constitution requires a unanimous jury verdict in every case other than the decision whether to recommend life or death. I understand the state's argument is that you don't, they interpret McKinney as saying, and I think it's dicta in McKinney, but Scalia had said something along the line, Justice Scalia had said something along the lines of states which entrust the selection decision to the judge alone may continue to do so.
In light of that, is it your argument that the Constitution of the United States requires any jury recommendation at all? And if not, why the one you're choosing?
Well, I think if the Constitution doesn't require any jury participation at all in the selection decision, I think it's important to note that Florida does not do that. Florida, like all states...
No. Please return to my question.
Okay.
If the U.S. Constitution doesn't require any jury recommendation at all, why then, because it sounds like you concede that, does it require 12-0 as opposed to 8-4?
Would it be okay if it required 2-10? I mean, if a state is going to, first of all, I'm not conceding that the Constitution
Okay, so let's start there. If you
jury.
don't concede that,
Right.
cite a case for the proposition that you're right.
I don't have a case for the proposition that I'm right. I don't think the state has a case for the proposition that I'm wrong, other than
We'll see about
dicta,
that.
other than dicta and McKinney.
We'll see about that. But.
Right. Okay. But I did. You know, Florida is a state that has jury participation, and does that mean, for example, that biased jurors can sit? Does that mean, for example, that if it's a 4 jurors recommend death, that's enough? 2 jurors recommend death? Could you have a 4-person jury, a 9-person jury? I mean, I think if you're going to have jury participation, you have to do it right. I think there are cases that talk about unanimity being an important protector of reliability. One real good case on that is the Daniels case out of Connecticut that was cited with approval by this court in Steele. Justice Clarence Thomas, in a case I want to say it's called Jones, that this court may have cited recently, talks about the importance of the community participation in adding to the reliability of the death sentence.
Do you make a distinction between reliability for fact-finding versus trying to apply that concept to what's essentially just sort of a judgment, a moral judgment almost? I
don't disagree. I don't disagree that the weighing process is a moral judgment as opposed to a finding of fact. I don't disagree with that. I think that jury participation, community participation in the moral judgment is important. And I think that the other problem is that eligibility under Florida's current system is way, way too easy. Eligibility in Florida does not separate the few cases from which the death penalty is appropriate from the many cases in which it's not, because almost everybody starts off death eligible. The felony murder, which is generally considered less culpable than premeditated, will start off with that one automatic eligibility aggravator that makes you death eligible from the very beginning. If the jury finds that you committed the crime in the course of a convenience store robbery, under what Justice Coriel was saying, they can just go home. They can't do it under the statute. But constitutionally, all they'd have to do is say, this was a convenience store robbery, we're done. We made the finding. And then granted, there are a couple of stray felonies that don't qualify for the aggravator, but they're not the common ones. They're ones that rarely happen. I mean, all the common ones, burglary, robbery, kidnapping, sexual battery, they're all automatic aggravator. The ones that aren't will always be some other. For example, resisting arrest is always going to involve the murder of a police officer, except in some random case where it's a stray bystander. Same thing is true of some of the ones with child abuse or whatever. But then, let's say you got a case that's not a felony murder. The borderline between CCP as opposed to simple premeditation has been pretty much eviscerated. In order to not qualify for CCP under the current case law, it pretty much has to be like a spur-of-the-moment decision. It's supposed to be like a protracted period of careful planning, calculated plan. But under the case law, it's often not that. HAC, okay, what kind of crimes are not HAC? Basically, random shootings where the victim doesn't see it coming. Okay, strangulations are HAC, stabbings are HAC, beatings are HAC, drownings are HAC. A shooting will not be under the case law unless the victim has some reason to kind of know in advance and contemplate the fact that they're about to get shot. Okay, so if you take all of now it's up to 18 aggravators in Florida now as of October 1st, because they keep adding them, like the Law Review article said, they keep adding them like Christmas tree ornaments. You can, Justice Eaton said it's hard, Judge Eaton said it's hard to imagine a Florida case that doesn't have at least one aggravator, one eligibility aggravator. Now, I can imagine one. I could sit down there and kind of write like a short story where I could imagine a case that wouldn't have one. They're few and far between. So it stands the death is different principle on its head. The whole concept, worst of the worst, I mean, you know, that is... If you go back and look at the case law, because I've been doing this for too long. I've been doing this for 45 years or close to it. And if you look at the case law, how it evolved, you used to get a lot of kind of what you might call, Justice McDonald would have called your garden variety convenience store cases. And they would come in as death cases and they would get reversed. And then there was a period of time through the 80s, through the 90s, even into the early 2000s, when you were getting proportionality reversals. And the result of that was that judges were figuring out what was a true death case and what was not, what they were likely to get reversed on. Prosecutors were figuring out what was a true death case, what was not, what they were likely to get reversed on. And over the course of time, you started, and this was bad for people like me, because I would get a case and I'd say, oh man, this is a bad one, because that was the ones that weren't as bad weren't coming in death. Then when you had the unanimity statute, it became even more so. And what I'm arguing is that the way the system was before, when it was constitutional under Furman, it was working. It wasn't perfect. I would have liked, for example, residual doubt to be recognized as a mitigator. But if you compare it with the other capital systems around the country, it was better than average. It was working. For whatever reason, they decided this is working too good. Let's fix it.
I mean, your word "working" is doing a lot of work in that statement, and I respect what you're saying. But do you want to? I want to make sure you get to your other. Yeah, arguments here, because you're down to
like
6
I say,
minutes.
I was going to make the same caveat that everybody always makes: is anything I don't get to, I'm going to rely on the brief. I got 20 minutes, and I probably got like 6 now, and that's fine. But okay, go on my other issue. Under Florida and federal constitutional law, can a defendant choose to tank his penalty phase or his penalty retrial? Yes, provided that there's no bona fide doubt as to his competency. Can a defendant waive his constitutional rights to a jury and to present mitigation? Again, yes, if there is a sufficient colloquy and if the state meets its burden of showing that the waiver was...
What evidence would you point us to in the record that would suggest a concern about your client's competency at the time he made the decisions in this case?
Concerns about my client's competency?
Yes.
essentially nonsensical reasons he gave for.
So the evidence you point us to is his decision against the advice of counsel, notwithstanding the fact that counsel didn't have any concern about his competency.
I don't think I'm saying just that it was against the advice of counsel. I'm saying that I'm relying on the statements in, for example, Nowitzki and Pridgen, that say that even though a defendant's his decisions may not be evidence of incompetency, but the reasons he gives for those
So
decisions.
is it your position that no competent defendant could reason to the same conclusion that Mr. Figueroa Sanabria did and say,
No, that's not what I'm saying.
So tell me a little bit about what I would look to in the record under the rule of law you're proposing to establish a concern about the defendant's competency, because it doesn't seem like Judge Siracusa had one, and it doesn't seem like your client's trial lawyer had any basis to say.
After the fact, he said he didn't. I think that was largely a cover your posterior. But and again, I'm trying to answer multiple things at once here. I mean, when this went back, there were issues with these lawyers and with Mr. Figueroa back in the other appeal. Mr. Figueroa was pro se for a time, and when he decided he couldn't be pro se, there's too many roadblocks to doing it, Judge Siracusa appointed the same lawyers. Did he have the discretion to do that? Probably. Was it a good idea? Probably not. When it came back after the reversal, again, he appointed the same lawyers. Do I have legal grounds to say he wasn't within his discretion to do that? No. Was it a good idea? No. But I think that if this was just a question of him making a decision to do waivers, and for example, if he was a death volunteer, this could be a case like Boatman or the one that was argued yesterday, Richard Bishop, that kind of bootstrapped Boatman. They didn't get to that issue on their oral argument. But if this was just a question of like where Dr. Werner and Boatman kind of said, well, he's competent in every other way, but I just don't think, I have doubts about whether it's free because he wants to be on death row. This isn't that. Figueroa is not and has never been, to my knowledge, a death volunteer. The record in either the first case or the second case doesn't establish him as a death volunteer. Nothing that I can say outside of confidentiality would in any way indicate to me that he was a death volunteer. And there's two kinds of death volunteers, and this is important. There are the ones who want to die. There are the ones who just don't like their life. Maybe they feel guilty. Maybe they just hate, and they want. Those are the ones who want to waive everything. They try to waive appeal unsuccessfully so far. They waive post-conviction. They just want to be executed as soon as possible. That's James Hamlin. That's James Robertson from 10 years ago. Then you got your other kind of death volunteers, and this can be rational, and I think Dr. Werner recognized this in Boatman. There are the people who look at it and say, I'd rather do 10 or 15 or 20 years. I'd rather do life on death row than be in general population. I'll take my chances with, if I eventually get executed. Maybe I'm an older person, whatever. The creature comforts are better on death row, as it turns out. That didn't used to be the case, but you get an individual cell, you might get a TV, you're safer, you don't have to worry about gangs as much, you don't have to worry about sexual assault as much, you don't have to worry about all the craziness. So there are people who make the rational decision, I want to be on death row rather than in Gen Pop. That's Boatman, that's Scotty Allen, that's probably Richard Bishop. Figueroa is neither of these. Figueroa, his signature characteristics, I can't say. I'm not a psychiatrist or a psychologist. I haven't done a competency inquiry. Nobody has done a competency inquiry since 2019. So I can't say he's psychotic or mentally ill or incompetent. All I can say is he might be, that the reasons he keeps giving are irrational. They don't evidence a rational or a factual understanding of what he's waiving. He fixates, he perseverates, and that should be obvious to the trial judge, both in terms of ordering a competency evaluation, which we know he's capable of doing because he did it in 2019, sua sponte, or in terms of having an adequate colloquy to find out, among other things, what kind of medication this guy's on and what kind of effects they have on him. The judge in this case was saying things like his idea of a voluntariness inquiry is, well, I don't see any hesitation in your eyes. You seem pretty sure of this. He seems to really want this. The medication part of the colloquy boiled down to essentially, you're not on any psych meds, are you, right now? And the answer was no. He's on a panoply. He's on a plethora of physical medications for diabetes, and I cited a lot of case law from everywhere that talks about that.
I'm sorry to interrupt you. You can take 30 seconds to finish up, and then 2 minutes for rebuttal.
Okay, I've just done that. A lot of case law, civil, all kinds of case law that talks about the psychological effects that physical medications can have, diabetes medications can have, including confusion. And I haven't had a chance to get into, it's in a brief, all the stuff about doesn't matter what happens here because I'm going to appeal anyway. Doesn't matter what happens here because I'm going to appeal anyway. None of that makes any sense for reasons that I'm going to have to rely on the brief on.
Okay, thank you.
Thank you.
Appreciate it. 2 minutes for rebuttal.
May it please the Court, Timothy Freeland here on behalf of the state of Florida. Beginning with issue 1, there is no record evidence that the defendant lacked competence. In fact, we have a statement from his own counsel that I see nothing that my client has done to lead me to believe that he is not competent.
What do you make about his statements about appealing?
I think he was right. He had the right to appeal, and here we are. He appeals what he can appeal. That his attorney told him that you're going to be waiving certain things. Exactly what was he required to tell his client? The case law does not require that he get into, well, you're going to give up this issue and this issue and this issue and this issue. That's not what's required. What is required is a rational and factual understanding of what it is that he's waiving. And he clearly understood that. Counsel told him, this is the same judge that sentenced you to death previously. If you waive your penalty phase jury, you're giving up my only shot, your only shot at getting a life recommendation. That's enough for him to understand that gives him a rational and factual understanding of what he's waiving. The other issue is that is this preserved? Was it even raised in the trial court? And it was not. So we have that to wrestle with. That's my argument on issue 1. On issue 2 and issue 3, I'm going to rely upon my brief unless the court has some questions about whether we need to revisit Lawrence or whether we need to revisit Poole. I don't think that we do. Thank you.
Thank you.
Okay, quickly on the preservation point. The competency issue does not need to be preserved by the client or by, which he's not going to do anyway, or by the counsel. The case law's legion that responsibility, the judge has a responsibility to order a competency evaluation sua sponte, like he did in the 2019 proceeding. And on the preservation point, also on the waivers, there is some case law. There's like case law one way and case law in the other way as to whether or not you have to move to withdraw your appeal, to withdraw your waiver in the trial court before you can raise it on appeal. The state waived that issue by not making that argument in their brief on appeal. But in addition to that, there's the cases that say that you have to move to withdraw your waivers in order to raise them on appeal. Go back and look at the original case that says that, Griffin, and then DeSar and recently Donald Williams say the same thing. Griffin is based on the assumption that they cite Robinson, they cite the rule, and now, of course, there's Dortch, and they say, well, you have to move to withdraw a guilty plea, and we're going to apply that. We're going to apply that to waivers as well. We think the same rationale applies. Well, in capital cases, you don't have to move to withdraw your guilty plea, and in point of fact, this court, for years and to this day, will review sua sponte sufficiency of the evidence in every murder case, every capital murder case. And if there's no trial, if there's a guilty plea, the court will review the voluntariness and the waiver and everything else on the plea. That would be recently Lorenzo. That would be the Gill case. The court. It's a completely different rule in a capital case than it is in a non-capital case. Dortch doesn't apply. Griffin is essentially wrongly decided, and I would point to the Boatman case where this court did review the voluntariness of waivers, where there was no motion to withdraw it below. In the Scotty Allen, the post-conviction case, the court actually said the issue of the waivers could and should have been raised on direct appeal. So I don't think there's a preservation problem here at all. The state says the defendant was not required to have an attorney-level understanding. He was required to have a rational as well as factual understanding. Would it have been too much to ask, given the things he consistently said throughout these proceedings to Judge Syracuse? It would have been too much for Judge Syracuse to say, your guilt phase appeal, Mr. Figueroa, is over. Instead, he said things that encouraged Figueroa to believe that his guilt phase appeal, which is what he evidently cared about, was still pending.
Okay, you can have 10 seconds to finish up. Thanks. Are you done? Yeah, 10 seconds.
Say, thank you then for 10.
Okay, all right, thank you. We're done. Okay, our final case for today is Rivera versus State of Florida, number 2024-1141. Good morning.
My name's Philip Mass. I represent Julio Rivera in this appeal. And I cited in the brief 6 points on appeal, and they were primarily from the trial court attorney's preservation of the issues. And I thought those would be good issues to present to the court. He did preserve a lot of constitutional issues that have been ruled on before and were found to be not unconstitutional. So I wanted to focus on some of the trial objections, and then on the proportionality, the proportionality issue is a drum I keep beating ever since Lawrence. And I kind of have a special connection to that because the first time I was here was during COVID, and I had the Bargo case, which was a horrible set of facts, and proportionality was still being applied at that time. And right in the middle of the initial brief and the answer brief, Lawrence came out, and Lawrence obviously did away with proportionality. I addressed it in my reply brief, and I still think that, I mean, I know what the law is. Florida does not have to do proportionality review. But at the same time, I don't see how it aligns yet with the federal jurisprudence. And I do kind of go with Justice Labarga on his dissent on some of the things he's brought out in Lawrence, and also in this case, he pointed to a federal statute which requires an alignment of the jury before a death sentence is imposed. But first, I'd like to talk about, and these are evidentiary matters, but they could have made a difference. Point one was the trial court erred in instructing the jury on the statutory aggravator, cold, calculated, and premeditated. Now, the reason why I brought that one up is it was an 8-4 verdict, which is just on the tipping point. And the facts of the case clearly show that there was no premeditation, there was no planning, there was no cold calculating advanced plan on this. To boil it down, there were two people, both involved in the drug trade, O'Valle, who got shot, and Rivera, who shot him. And they were in a rental area. O'Valle was going to set up another drug deal with his cohort in New York. Rivera wanted part of that. O'Valle basically said no. And Rivera, in front of a witness, walked up behind him and shot him one time in the head, killing him, and then took the witness home, dropped her off, and then went back to the scene and told the police, I'm the person you're looking for. So that is so far afield from cold calculating and premeditated. You don't shoot people in front of witnesses. The trial attorney objected. The objection was overruled. That language went in front of a jury. And because of the 8-4 decision, and this is the reasoning of the trial counsel, which I adopt, because of that one vote, this instruction and the argument on that, there's a reasonable possibility that it persuaded one juror to vote for the death penalty, even though they did not find the aggravator applied. Okay, they turned it down. They said, we're not going to apply this aggravator, but there's still a reasonable possibility that in the minds of one juror at least, they applied it. The other point, and I'll jump down to 3 because 2 is the proportionality argument. And this again was preserved by the trial counsel. The aggravators that Mr. Rivera was found guilty, liable of, was the prior violent felony and the prior conviction aggravator. He argued them as being status aggravators, and I adopted that. When I want to say the personal aggravators, like cold calculated, premeditated, HAC, where there's real kind of an involvement with the victim, they weren't applied. The state never even asked for HAC. And when they went in front of the jury with CCP, it was rejected. So Rivera the two aggravators were status. There was no real interaction between Rivera and the victim on the aggravators. So I thought that was a good point to bring up, and I put it in the brief. Sorry, Judge?
What makes that a good point?
It makes it a good point because the aggravators are abstract.
Well, but I mean, he one of the reasons why he had the aggravator was because he had killed someone before. He had tried to kill someone else. He spent X amount of years in prison, and then within a year he killed again. I mean,
correct, Judge.
So what's I don't understand why is that not a legitimate aggravator?
I'm not saying not legitimate. I'm saying in this case, the type of homicide, he shot him in the head. The state did not ask for HAC, which they could have. And when
they couldn't. How could they have asked for HAC on those facts?
Well, they evaluated they asked for CCP, which is just as abstract as HAC. And when you look, there was really no planning. So when what we're calling a personal aggravator went in front of the jury, they rejected it. So he's liable on a status aggravator. I mean, that's the argument. It's like having a driving under a suspended license. It's a status he's in. So he's in that status of someone who had committed a prior felony, who served time in prison, but yet in this particular set of facts, when they put a violent aggravator in front of the jury, they rejected it. The other one is the trial court committed reversible error by admitting hearsay testimony that materially prejudiced the jury. This error was not harmless. The jury heard the witness, Ms. Behar, testified that she overheard a conversation between Mr. Rivera and one of his cohorts up in New York City. She couldn't understand all of the conversation. Part of it was in English and part of it was in Spanish. And the trial counsel did object to hearsay. And the state came back with effect on the listener, which is not in the evidence code. But they put that in front of the jury. She objected on that. The trial judge ruled that whatever she testified to was an admission by the defendant. The defendant never testified. Never made a statement, never testified to anything. She overheard a conversation which she didn't completely understand. Part of it's in English, part of it's in Spanish. And then she testified to the jury that so-and-so said this and so-and-so said that. Complete hearsay. And the reason why it's important, it was incriminating hearsay. So I put that in. The judge did rule that it was an admission by the defendant. She did not rule that it was effect on the listener, but it was admission by the defendant. But there's no admission. And that was kind of the gist of that. The 1.5, the trial court erred in not properly evaluating and weighing the mitigation evidence presented by the appellant. The appellant, two important aspects was the two medical people said he had brain damage. Dr. Wu, who seems to appear in all these cases, and another neuropsychologist said that he was suffering from brain damage. And none of the and it's just hard to it's just hard to kind of accept that when you have that type of physical evidence that the trial court would not give it any weight. And in all the 52 aggravators, there were many that were less than slight weight, which I don't understand that category. There were some that were less weight. There were none that were great weight. I think if someone has a brain damage, which a reliable medical professional analyzed, then that should be given some weight, and it wasn't. So I argue that in this, when you look through all the mitigators, none of them are really given any credit. And the court.
Did the defense experts ever really link his mental damage to the murders in any way?
Sorry?
Did they ever provide any connection or link between what they were saying, his brain damage, and the actual murders? Yes,
they did. There's part of the record where Mr. Rivera is tweaking, and apparently that's a sign that in a stressful situation, they can't make a rational thought. Okay, and that's what he argued. When they're put under certain stressors, because of this type of brain damage, which, in full disclosure, I am learning more about as we do more of these cases, that if some of these people can't function right under a stressful situation, and they react that way. And that's what Dr. Wu said. He couldn't logically, just calm down. He went and got a gun and shot him because he was under stress. That I've seen in other cases that are coming up before this court. They're not here yet. And that the malfunction of the brain seems to cause stress that makes people act unreasonable and perform these type of acts. All right, so that, I pretty much argued that in the brief, and I don't want to, spend too much time on it, but I thought that there should have been more attention given to the mitigators. And the one that I'd really like to talk about is the proportionality review. Now, I followed the cases. I was involved basically with that first case, And Justice Kennedy asked me some questions on that at the time. It was the Bargo case. It was a horrible murder. They tortured this person. They burned him. They did all this. He had mental issues. He was sent back for a new penalty phase. Guilty, death penalty imposed. In the middle of all that briefing, Lawrence came around, and proportionality disappeared. Justice LaBarga wrote a large dissent on that. And the issue that I see is the Florida death penalty process wants to, unless I'm wrong, wants to align pretty much with federal jurisprudence, in a conformity type of issue. But I don't think it's there because in the federal jurisprudence, they still have to have unanimous verdict or someone is executed.
Could you apply, though, the proportionality, if we had proportionality, what's your best authority for the idea that someone who has already committed a murder, already had an attempted murder, kill someone else again? I understand that the facts of this specific crime that would obviously be a stronger part of your argument on proportionality. But what's your best authority for that mix of circumstances not satisfying proportionality review?
Okay, well, if I understand the question correctly, in Florida, you don't have a full verdict, unanimous verdict.
No, I'm saying apply it. So you're saying that it's let's assume we have proportionality review. Why would this qualify as a case where we would say?
This case?
Yeah.
Oh, okay. Well,
isn't that what we're here to do?
Okay. Well, this case.
Figure out this case.
Yeah, this case. If you look at Lawrence, which was the case that did away with proportionality review, they kidnapped a young lady, they tortured her, and they ate her. If you look at, and now that's bad. If you look at Bargo, they kidnapped one of their friends, tortured him, shot him, and burned him. If you look at Rivera, he walked up behind someone who had no idea he was there, shot him once in the back of the head, and then took the witness home. So when you compare those cases, that's where I think proportionality review would be helpful, especially when you don't have unanimous verdicts anymore.
I think the chief was focusing on the priors, the prior murder, the prior attempted murder. And it's like this guy's in the habit of murdering or attempting to murder people, and doesn't. That kind of points toward the appropriateness of the penalty. That's a big part of the. Wouldn't that be a significant part of the analysis if we were doing that?
To be put into a proportionality review?
Yeah.
Yes, it would be. Yes. No, I'm not doubting that. It would be. But then again, if you look at the facts of his prior homicide, I think he was very young. I think now we're saying that the brain isn't fully developed till you're 24. I think he was in his early 20s. He was remorseful, and I think he shot himself after that. That's how remorseful he was. And I know there was a long period between crimes, but he was in prison. So. But no, that would be something to obviously look at for proportionality review. And that goes back to the fact that the aggravator was a status type. I mean, if he had prior crimes like Bargo and Lawrence, there's absolutely no doubt he would be, a recipient of it. And as a matter of fact, when I did Bargo, I couldn't find a case that was worse until I ran into Lawrence. What could be worse than this? So I guess basically, my biggest argument here would be that proportionality review is still important and is still critical, especially now, since we don't have a unanimous verdict requirement. If there was a unanimous verdict requirement, maybe proportionality review wouldn't be as critical because we have a full verdict from the jury. And in terms of, it starts out with these aggravators, these are supposed to be the worst of the worst. Well, in 1995, there were 7 statutory aggravators. In 2005, there were 13. 2015, there were 17. 2025, there were 18. And if you look at the aggravators, any homicide could be put into one of those aggravators. Any homicide. That's how broad they are. So I'm not here to make an issue of the aggravators. I'm just here to say that, with all due respect, I still think that there's a lot that goes on in federal jurisprudence that Florida has not adopted yet. And I got a little bit into the supremacy clause, and I'm not trying to put myself out there as a constitutional scholar, but in the federal arena, you do get proportionality. You don't have to. Foley versus Harris says you don't have to, but you do get it. And even in their code, which was cited in Justice Labarga's dissent, they do have a statutory requirement that the jury comes back with unanimous decision for the death penalty. That's where I'm at.
Thank you very much.
All right, thank you.
You'll have 11 minutes for your rebuttal.
All right.
May it please the court, Naomi Nichols on behalf of the state. As far as the cold, calculated, and aggravated goes, the court allowed the state to argue it. There was an extensive argument before penalty phase about whether or not they would go to the jury. The court decided that it would. The court looks to whether or not there's competent substantial evidence in the record supporting that aggravator. And here we have an execution style murder, that there was evidence in the record also that the defendant procured a weapon, and he, in his recorded jail call that happened less than 2 weeks after the murder, he talks about how the other firearms that belonged to the victim that were found in the storage shed, he had unloaded those. He didn't like to have them loaded in the storage. So there is at least an inference to be drawn that he had loaded this firearm in preparation for it. And then the facts of the time frame right around the murder, they had this conversation about the drug deal that was going to go down in New York, wanted a part of it, and the victim told him, no, you got this. And as you learn from the jail call, when he's talking to one of the people that was on that phone call, explaining why he killed the victim, he was feeling disrespected. He felt like he was tied down to the storage shed. He felt like he was being used as a scapegoat. And this was something that had been building. He had been there about a month. I think the evidence showed that he came in early November, maybe 4 to 6 weeks before the murder happened. And he told Jonathan Flores on the jail call that he didn't want to come, but he came anyway, and he wanted to leave, but he couldn't. He didn't have money, and he didn't have a car, so he couldn't leave. And this is what he did. It's also important to keep in mind that this...
ask you just one thing. I mean, and I agree with you on the facts. It seems like whatever relationship he had with the victim in this case, it was something that was worsening by the minute. But it seems like on the day of the shooting, at the moment of the shooting, it seemed like he was in the middle of a rant with whoever else was present about this other guy, the victim, and was going on and on about it, and all of a sudden he just took the gun out and just shot him. It seemed like, even though the reason for it may have been building up, it seemed like a moment, he was in the middle of a rant, he just decided to take the gun out and shoot. I don't know that all that planning as far as shooting him was involved. And dealing with this heightened premeditation that must exist in CCP, how is that not in line with the, like Justice McDonald used to say, the basic run-of-the-mill, liquor store robbery, where the guy just walks in and just boom, shoots the guy and then takes the cash register money?
If you read the testimony of Casey Bathger, who was sitting right next to the victim when he got his head shot, she said that this conversation had gone on. When they first arrived, they smoked a blunt, they were talking, they were hanging out. The conversation with the people in New York happened. The victim and the defendant went outside for a time. They came back inside. She went to the bathroom. She came back. And at one point, she noticed that he was tweaking, and she described that as meaning that he was pacing back and forth. And that's what she described as tweaking. And the victim told him to take another hit of the blunt so he would calm down and relax. Now, it's not exactly clear when that happened in relation to the phone call, if that tweaking was before or after. In the transcript, it sounds like it was just after they came back inside from whatever conversation they had had outside, and they left the storage shed. And then right before the shooting happens, the victim tells him, "We got to leave. We've got to go home and take my girlfriend's daughter to the store." And the defendant manages to position himself. "No, wait, let me show you my new toy before you leave." And he comes up behind the victim, and he's sitting there with his feet propped up on a bed. His shoes are off. His phone is, I think it was on the bed too. There were a couple of phones that were found. And comes up behind him, in a surreptitious manner so that he doesn't see it coming, with the firearm pressed very tightly against the back of his head. The ME testified that I can't remember the term they call it, but the way that the skin explodes is because, and there you can see the outline of the muzzle on the back of the victim's head. He pushed it in there and he held it tight and pulled the trigger. Like, there's no other indication of emotional frenzy, the tweaking back and forth. He might have been upset about something, or he also, as we learned in the Spencer hearing from Dr. Scully Danziger, he had been drinking and he had been smoking marijuana. And to her, he described the marijuana as something different than he was used to before he came out. So he was under the influence at the time, but there's no evidence of emotional frenzy.
But I mean, you would admit this is at best a borderline CCP case.
It's not a strong CCP case at all. There is evidence in the record to support it. It went to the jury, and ultimately they found it was not proven beyond a reasonable doubt.
What's your response to the argument that the state hasn't sustained its burden of proof on harmless error because of the 8-4, and it could have influenced the jury?
As far as CCP goes, yes, and harmless error? So the jury was instructed. We presume that the jury followed the law unless there's some clear indication that they did not. They were instructed before they deliberated, before the case, at the beginning of the penalty phase, they were instructed that you only weigh aggravators that you find proven beyond a reasonable doubt. You don't take into consideration any of the evidence of aggravators that you don't find proven, and they were instructed that again before they deliberated. And in this case, the CCP evidence, all of it came in during the guilt phase. There was no additional evidence for CCP that came in during the penalty phase. So even if the court had not allowed the jury to consider CCP, it wouldn't have changed what they heard during the penalty phase, which was the evidence that he had committed 3 robberies in the fall of 1993, and one of them was a murder. One of them, he shot a man's hand off. He killed the owner of a radio store right in front of his 2 children, and then fled, shooting at police officers as he goes, holds a gun to another man's head and forces him into his apartment where his family is, and held them there for a period of time. So when he gets out, it was only, he was on probation less than 6 months before he absconded, and 3 months later before he committed these murders. So my argument that it's not, there's no harm in this case is we presume the jury followed the law. And there's just no evidence in the record that they did not follow the law. And so there's no reasonable possibility that it affected the outcome of their recommendation.
It's interesting to me, and I mentioned this before, is how we constantly look at what a reasonable jury might do in considering harmless error, and yet hearing the strong evidence in this case, prior acts by this defendant, going to prison, being on parole, violation of parole, having killed somebody before, yet he walks up behind somebody and shoots him right in the back of the head, yet 4 people in the jury did not recommend that. So much for the reasonable jury. If ever there was a death case, you would think this would be a 12-0.
Right. The priors are very strong. It's a weighty aggravator, which is maybe an argument to be made for we don't want a jury override, which is what the legislature, I imagine, was taking into consideration when they made it 8-4 instead of unanimous. So as far as the aggravators not being enough, I've gone over what the aggravators were. Hearsay, so there were defendant statements that were admitted in the trial that consisted of the jail phone call and his statement to the victim about what am I going to get out of this deal. That's a defendant statement that came in. So that's a statement of a party opponent, which is excluded. It's an exception to the hearsay rule. And then the other one that was argued at trial was effect on the listener. So the state's position that it was not hearsay at all because the statements of the victim and Jonathan Flores were not offered for the truth of the matter asserted at all. We're not trying to prove that there was a drug deal about to happen in New York, that they was going to New York, that he would be there on Tuesday, or that Jonathan Flores wanted him to hurry up and get there. Like, none of that was offered for the truth. It was offered for the effect on the listener, who in this case is Mr. Rivera, when he heard that. And the effect on him was, I went on this deal, which made him ask that question and got the response from the victim, like, no, you're not getting anything. You got the storage shed, I'm giving you a place to live. This is what you get. You're not getting anything else. The mitigation, the court did not abuse its discretion in sentencing the defendant to death. In this case, she found specifically about this mitigation that the defense experts were not as credible as the state experts, particularly when considering the facts surrounding the murder, which the defense experts didn't know. They didn't question Mr. Rivera about those facts. They stayed away from that. And it was that the court was taking into consideration, I think, when she made her credibility findings about the experts, not necessarily, them not being experts, but that they didn't have the full picture at the time. And so that's what she was taking into consideration. There's nothing in the record to suggest that it was an unreasonable decision on her part. To the contrary. If the court has no questions on proportionality, I will let that stand.
Thank you.
Thank you.
Thank you, Judge. So just 2 points on rebuttal. In terms of the CCP aggravator, I quoted, or I cited on page 21 of my initial brief, Boatman versus State, Supreme Court, 2022-1547. And at the time it wasn't published, so that's how I have to cite it. That court stated, Supreme Court stated, it was a product of cool and calm reflection and not an act of prompted by emotional frenzy, panic, or a fit of rage, which is exactly what Mr. Rivera was doing, that the defendant had a careful plan or prearranged design to commit murder before the fatal incident. There certainly wasn't a careful plan when there's a witness there, and there was no prearranged design. And it's a heightened premeditation that the defendant had no pretense of moral or legal justification. Boatman goes on to say that the court laid out the factual basis in Boatman. The manner and circumstances of the crime demonstrate careful planning to ensure the desired result. The planning including the selecting the victim days in advance, which we don't see here, coordinating to obtain shanks and ligatures, which we don't see he coordinate anything to obtain a weapon. The guns are all over the place, and blocking a day room door. The evidence shows such facts as evidence, procurement of weapon, lack of resistance or provocation, and the appearance of killing carried out in a manner of course. Another case I cited was Miller v. State, 379, Southern 3rd, 1109, Florida, 2024. Again, it was Miller stalked police officers, planned it, had disrespect for law, and it was something that he carried out before he went and committed the act. So what's important about this, and this I just took right out of the trial attorney's, Terry Lenneman's memorandum in support of a sentence of life imprisonment for Julio Cesar Rivera, record 3888. Although the jury did not unanimously find the aggravating factor to have existed, there exists a likelihood that some of the jurors disagreed whether CCP applied or did not apply in this case. In a case where one juror made the difference between life or death, there exists a great possibility that a juror inappropriately gave the CCP aggravating factor weight in support of his or her individual verdict of death. And then it goes on to say, a judge should instruct a jury only on those aggravating circumstances for which credible and competent evidence has been presented, which it was not presented at the trial. The appellant raised the objection of CCP multiple times, and it's in the record 3554, 3558. In terms of effect on the listener, my understanding of effect on the listener, it's not part of the Florida Evidence Code. It's a common law principle, and the effect on the listener would be if what I heard. So if Mr. Rivera shot somebody and he said, I shot him because he told me he was going to attack, that's the effect on the listener, not a third party. They presented the effect on the listener as Mrs. Bearhart heard it, and she assumed that's why Mr. Rivera did what he did. That's not the way I understand the law. That's not the effect on the listener, and it's not in the code. I mean, it's more of a state of mind. So if Mr. Rivera would have heard someone tell him something and he reacted, it's not hearsay because it had that effect on the listener, which would be Mr. Rivera. And that's an important point because that was a big issue in this case. That telephone call, what she testified to, that was a big issue in the case. So that's the only rebuttal I have. Thank you.
Okay, thank you very much. We're adjourned.
All rise.